Another new act passed this year that would become law effective January 1st, 2025, are changes to the rights that a tenant may have against a landlord to bring an action against the landlord for what it believes is retaliation for certain actions that the tenant has taken. As you might be aware, there's an existing law has been on the books regarding retaliation by a landlord, essentially saying that a landlord cannot evict somebody or cannot evict a tenant if the tenant has complained to a government entity for some violation of law, violation of code. This act expands on that to give a tenant right to make a claim of retaliation for not just the landlord trying to evict them, but also other things like a landlord trying to raise rent, decrease services that it normally provides to the tenant, or threaten to bring a lawsuit against the tenant. The act also spells out different actions, additional actions that a tenant may have taken that a landlord cannot quote-unquote retaliate against the tenant for, in addition to just reporting a crime or ordinance violation to a government agency. Some of these additional instances may be if a tenant has joined a tenants union, or if a tenant has sought the assistance of a community association, not a government organization, or if the tenant feels that the landlord is retaliating against them because they've requested repairs to the property. If a court were to determine that a landlord has retaliated against a tenant under this new act, the consequences can be pretty severe for the landlord. The tenant could have a right to terminate the lease, and if such lease is terminated, to receive a return of the security deposit and all prepaid rent. The tenant could recover possession of the property if the landlord has attempted to evict the tenant or is in the process of attempting to evict the tenant. And the landlord could be hit with significant financial penalties, such as 2 months worth of rent or 2 times the damages incurred by the tenant, plus attorney's fees. Now, much of this may make sense. A tenant takes certain actions that they have a right to take, shouldn't be retaliated against. I think most people can agree on that if it's an unjust retaliation. One important aspect of this law that we will keep an eye on, and it's important for you to know about, is the burden of proof on who has to show what to prevail in any court action. This new act, in so many ways, creates a presumption that the landlord has retaliated against the tenant unless the landlord can prove that they have not. And that's important for a housing provider to know, because as they go forward, in order to help possibly defend against a claim, they want to have documentation for any steps that they take to be able to show that. Because if it's a presumption that you have done something and you have to prove that you haven't done something, if it's a he said, she said type of situation, you may not prevail in that situation, even if you were in the right. Now, some may say this goes against standard burden of proof in most other cases in our system, and that might be right, but that's not what the legislature passed here, and that's not what the governor signed into law, and so it is in effect January 1st, 2025.